is awarding of the punishment. The study that deals with the concept of punishment is called as Penology. The aim of Penology is that it provides a better understanding about the concept of punishment and what kind of punishment should be given to the offender. This lecture examines the following points, namely, number 1, the concept of punishment, number 2, the purpose of punishment, number 3, the reformative theory, number 4, restorative justice as a response to crime, and number 5, changes in the punitive theory. Now friends, let us discuss the concept of punishment. The term punishment is capable of several interpretations. Explaining a few, punishment is a societal reaction to the wrongdoer and involves infliction of pain or suffering by the state authority. It is important to understand that causing of pain is not the only objective of punishment. The word which is preferred is sanction. These sanctions are different depending on their primary purpose, like punitive sanctions, rehabilitative sanctions, and reprivative sanctions. Punishments have been defined in 5 terms, namely, number 1, the outcome of punishment is generally not acceptable. Number 2, it is a consequence of the violation of any law. Number 3, punishment is given because of the violation committed by the offender. Number 4, it must be actual or supposed offender for his offence. Number 5, punishment is given by the authority established by the law in the state. By infliction of punishment, the criminal law achieves precisely what it is supposed to prevent, and that is interference with someone's interest. The reason why the punishment was awarded in the earlier times was to punish the offender so that it creates deterrence in the mind of the offender and the society. This would further remove the offender from the society so that he does not go back into the society again and disrupt the peace of the society. But it is important to note that there is a sociological turn in penology. There have been seismic shifts in the social, political, and cultural environments of penal regime, coupled with the transformation of the criminal justice theories. The contributions to this part cover some of the most exciting and challenging areas of changes in the punitive theory. The next topic that we discuss is the development in the criminological theory. One of the most important parts of the criminal justice system is to understand the concept of crime, the reasons that led to its causation, and further to put forth the methods to stop the crime and to reduce the recidivism. The research community has made much progress in causes of crime and the functioning of the criminal justice system. Criminologists have at their disposal an overwhelming number of theories on crime and on the functioning of the criminal justice system, which are deterrence, incapacitation, and rehabilitation, which are of utilitarian or consequential nature. As disciplines, criminology and criminal justice are, however, continuously subject to change in the object of study, to new methodologies, and to other disciplines that deliver updated or new theoretical and empirical knowledge. In this lecture, friends, we ponder upon the recent and expected changes in crime, criminals, and criminal justice that force us to think about the new developments in the punitive theory. Friends, the world is rapidly changing, and the consequences of these changes is having a direct impact on the volume of crime, the types of criminal, and the punishment being granted to them, that is, the social control strategies and the law enforcement practices are simultaneously undergoing changes. The moot point of the concern should be the crime committed by the individual and not the criminal himself. The punishment should be decided on the basis of crime committed by the individual. Further, punishment should be awarded to reform the person who has committed the crime. The basis of punishment should not be a revengeful attitude of the society towards the person who has committed the crime. Now let us discuss the objectives of punishment. Punishment is the most effective way of controlling the crime in the society and is effective when it is immediate, inescapable, and severe. It is a powerful behavior suppressor if it is applied properly and with correct controls. It can be said that the approach to the punishment is rooted in the moral and legal philosophy that focus on the practical aspects of punishment. Further, it seeks to provide an understanding of the desired outcomes arising from various forms of state intervention. Punishment is not a behavior, but it is an institution. It is a part of the system that involves conduct and norms. It is an authoritative procedure for generating these norms, an authoritative procedure for decisions to impose sanctions, and some measures of practical power over persons or resources. To punish someone is not just to harm them because of something they have done. Punishment is given to return the offender for the wrong he has committed. It is a means of providing justice to the individual or the society and to bring back law and order in the society. Punishment not only acts as deterrence for future commissions, but it also reforms the offender. Now let us discuss another important concept under the criminal justice system, and that is the reformative theory. The ethos of the concept of reformative theory lies perfectly in the statement that has been given by Mahatma Gandhi, and I quote, "An eye for an eye will turn the whole world blind," and I unquote. Keeping this in mind, one of the best ways to deal with an offender is through reformation and helping him become a law-abiding citizen. This theory, known as the reformative theory, is also called as rehabilitative sentencing. It has come to the rescue of the offender and protects the human rights of the offender. According to the Encyclopedia Britannica, the idea of rehabilitation denotes that through treatment and training, the offender should be capable of returning to the society and functioning as a law-abiding member of the community. Departure from such strong convictions such as retribution and deterrence as being the sole aim of sentencing has occurred only in the recent past, with reformative or rehabilitative theory gaining momentum in many countries. This theory is a complete departure from the earlier theories which talked about giving punishment to the offender in the same ratio as the crime was committed. According to Friedman, and I quote, "Generally speaking, the increasing understanding of the social and psychological causes of the crime had led to a growing emphasis on reformation rather than deterrence, in the older sense as the best way to protect both the individual criminal from himself and society from the incidence of crime," and I unquote. This theory is on a positive notion which helps the offender to come back to the society and not inflicted with the intention to torture him. It therefore has regard for the humanity of person in that it does not see them as objects to be manipulated and controlled. Further, it does not deny the future development of personality of the offender. This theory is highly accepted and supported in the criminal justice system. The purpose of punishment is to reform the offender as a person so that he may become a normal, law-abiding member of the community once again. Here, the emphasis is placed not on the crime itself, the harm caused, or the deterrence effect which punishment may have, but on the person and the personality of the offender. And this quote was given in the judgment of the Supreme Court, Bachan Singh versus State of Punjab, a judgment of 1980. Further, this theory condemns all kind of corporeal punishment. The reformation of the offender is considered as an effort to return the offender back into the society as a better human being and a reformed citizen. Reformative or rehabilitative theory aims at the process of reintegration of the criminals into the mainstream of social life, thereby containing recidivism at any level. Salmond supported the argument that there should be an overall development of the criminal when he is sent to the prison. So sending an offender to the prison is not just to isolate him from the society, but also to help him have a purposeful and a meaningful life, so that once he comes out of the prison, he does not have a problem adjusting in the society and the society accepts him with open arms. The Supreme Court in the case of Narottam Singh versus State of Punjab 1978 observed, and I quote, "Reformative approach to punishment should be the object of criminal law in order to promote rehabilitation without offending community conscience and to secure social justice." And I unquote. Further, punishment according to the reformative theory is seen as reforming or the rehabilitation of the offender, but not to destroy him. Reform and rehabilitation are directed at tackling the cause of the offending behavior, which can be achieved by bringing the offender back into the society and giving him a normal life. The difference between reform and rehabilitation is that rehabilitation plays a positive role and brings about changes in those who are willing to change. It talks about addressing the future behavior of the offender and helping him become a civilized and an acceptable citizen of the society. On the other hand, reform focuses on changing the present behavior, attitude, and thinking of the individual. But it is important to note that both the reformation and the rehabilitation is an important part of the criminal justice system. Further, they are also important because they are changing aspect of the punitive philosophy. The rehabilitative approach has to ensure social tranquility and peace. One of the most important aspects of rehabilitation theory is that it always keeps into consideration the dignity of the offender, and that is, keeps the humanitarian approach in mind. The theory of rehabilitation incorporates various programs to make people confident, cooperative, and self-dependent. As Gandhiji has rightly said, I quote, "Hate the sin and not the sinner," and I unquote. It should be a guide in the administration of criminal justice. This theory is based on the principle of forgiveness, wherein forgiving an offender or showing mercy on the offender can help him repent for the crime committed by him and reform him. This would further bring a change in the personality and the character, and he would make all efforts to become a useful member of the society. One important terminology used is purposeful activity, which includes variety of activities and pursuits which are specifically tailor drafted for the purpose of rehabilitation and reformation of the offender, which can be provided either inside the prison or outside. So under the reformative theory, the punishment should be tailored keeping in mind the offender and the benefit to the offender rather than to anyone else. The activities which play a vital role in the reformation and the rehabilitation are providing education, training activities, physical education, programs that deal with substance abuse, family visits, community work, and workshops. These kinds of activities provide offenders with constructive and productive use of their time, and which are integral to the maintenance of law and order within the society and an essential aid to the rehabilitation and the reformation. Now let us discuss another topic, that is restorative justice. Restorative justice is also known as positive justice, relational justice, and restitutive justice, and it is reducivist in intention. Restorative justice has started gaining momentum amongst the policymakers and academicians. Restorative justice is a process that facilitates in having a discourse between the offender and the person affected. This plays a very important role in chalking out a path for not just the reformation of the offender, but further leading him to become a part of the society. It is based on the concept of cooperation and teamwork that focuses on peaceful cohabitation of both the offender and the victim in the society. The ethos of restorative justice is inclusionary, an alternative to the criminology of other, in which offenders are viewed as a class distinct from the law-abiding and against whom the public needs to be protected. It may entail further activities that derive from victim-offender mediation that typically embrace a wide range of measures to help repair the harm suffered by the society. It appears to open ways of dealing with the aftermath of crime that are more satisfactory for the victims, more constructive for the communities, and more integrative for the offenders. Punitive responses to crime give the victim not only a short-lived sense of justice by inflicting pain on the offender, whereas restorative justice has the potential for providing an enhanced sense of justice to the victim by ensuring that something positive is done by the offender to meet the needs of those who have been harmed by the crime. Further, this method helps in reducing the level of recidivism since the approach is not socially destructive. In an era that is dominated by penal populist responses to crime, restorative justice becomes viewed as a soft option and alternative to punishment. Now let us discuss another important topic, friends, and that is community service. Community service nowadays is growing rapidly as an alternative to prison. In this, an offence that is legally punishable is redeemed by number of hours of unpaid work for the community. This type of punishment, and this is what makes it original, requires the consent of the convicted person who may, if he prefers, choose to go to the prison instead. It is also a modifiable penalty. It is adapted not only to the offender's skill but also to the time at his disposal. He thus pays his debt to the society outside his work hours. To this end, he is monitored not only by the institution that benefits from his work but also by another person, either a paid or a voluntary social worker or a probation officer. It is very positive in the sense that the people can be punished without taking them away from their work and families, making them pay in different ways for the harm they have caused. Post-sentencing rehabilitation. Prisons are still self-contained, hidden places that society would prefer to forget, which is why there is an increasing tendency to remove them from such an institution. As long as they remain closed places, they will resist all attempts at opening them up to the world. By humanizing the conditions of detention and making life inside prison as similar as possible to the life outside, the negativity may be reduced to a very large extent. Quite apart from the need to respect prisoners' basic dignity, promoting the policy of reformation means better preparation for their return to the normal life. Friends, this would further give them a chance to reintegrate into the society without sinking back into the criminal ways. This is why the conditions must be created for prisoners both to want and to be able to return to the society. The example of drug addicts illustrates the worth of such work, like in this case, the time spent in the prison should be used as much as possible to wean them from the habit in a positive manner by removing all desire to return back to addiction. It is vital that the prisoners be prepared for their release, which is why the very important moment determining to a great extent the course of their rest of their lives. So in the conclusion, friends, I would like to quote, "The mood and the temper of the public in regard to the treatment of crimes and the criminals is one of the most unfailing tests of the civilization of any country," and I unquote. And this statement was given by Sir Winston Churchill. The justification of punishment poses one of the most difficult jurisprudential issue. Everybody has a view on what punishment is and how it is to be carried out, though moral sensitivity often gets into the way of an objective analysis of the subject. Crime prevention will never disappear. The lecture has considered a number of issues connected with the concept of punishment that will help in not just crime control but also crime prevention. The concept of punishment has been explained, and further, the aim of reintegrating the offender into the society through the use of restorative justice is also discussed. Crime prevention is a social process. Inevitably, it will involve many different people and institutions and many different sets of aims and objectives. It needs to be based on explicit guiding values, progressive principles, and extensive social participation. Government needs to initiate a process whereby both they and the local stakeholders become more reflexive about crime prevention and why it is important. The process of crime prevention is not just technical but also involves expression of values. To succeed, it must encompass some vision of the good society that should be based on participatory model that allows maximum liberty while simultaneously promising safety and security for all. It is important to understand that crime prevention and awarding of punishment should ultimately talk about positive community relationships. The principles discussed above are the guiding principles that should underpin any rehabilitative policy and which are as fundamental as crime prevention for the well-being of the society. If we take into consideration the aspect of reformation as the main object of prison policy, then the time spent in the prison should no longer be viewed as punishment. The reformative theory focuses on the future of the offender and does not consider the past. Reformation brings changes in the personality and the behavior of the offender, and therefore punishment is awarded keeping in mind the welfare of the criminal. Just as how life imprisonment is seen as the rule and death penalty the exception, imprisonment in itself must be seen as an exception, with alternative methods of punishment as the rule of law. With this, we come to the end of lecture, hoping to see you soon in another lecture. Thank you so much, everyone.